Hello and welcome to this new chapter on the history of international investment law. In this chapter, we will focus on the development of international investment law. How did it emerge and in which historical context? What were its main features? We will analyze these issues together in this chapter. To do so, we will discuss in section 1 the claim to a new international economic order that was made in the aftermath of decolonization, as well as its impact on both international law and foreign direct investment operations, which I will refer to as FDI operations. In section 2, we will analyze the strategies adopted by developed and developing states that led to the birth of international investment law. We will then wrap up this matter in the conclusion. The end of the Second World War was marked by decolonization and a wave of independence. The newly independent states acquired not only their political sovereignty, but also their economic sovereignty over their natural resources. This was recognized in Resolution 1803 on the permanent sovereignty over natural resources, which was adopted in 1962 by the United Nations General Assembly, that I will call from now on the UNGA. Against this backdrop, these newly independent states, together with other developing states, used their voting power at the UNGA to adopt in 1974 resolutions 3201, 3202 and 3281. The aim of these resolutions was to establish a new international economic order and to draw up a charter of the economic rights and duties of states. Crucially, this charter provided for the right of states to treat foreign investors in their territory according to their domestic law. In addition, the charter set out their right to compensate expropriations and nationalizations according to their own relevant laws and regulations. In other words, developing states promoted rules which ran counter to customary international law, which we discussed in Chapter 1. However, as you know, the resolutions adopted by the UNGA are, as a matter of principle, non-binding. As such, they do not form part of positive international law. But they can have an impact on customary international law. Hence, the question is, what was the impact of resolutions 3201, 3202 and 3281 on customary international law? In short, it cannot be said that they led to the creation of new customary international law rules on the treatment and protection of foreign investors in the territory of host states. This is due to the strong opposition of developed states to these resolutions. Their opposition meant that there was a lack of opinio juris, an essential component in the establishment of customary international law. However, on the other hand, the resolutions were considered by many to have dismantled the existing customary rules. In any case, these three resolutions resulted in great legal uncertainty. This uncertainty was detrimental to all stakeholders involved in FDI operations, not only to foreign investors, but also to developing states, which largely depended on such operations to foster their economic development.